Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we are going to be talking about Young Thug and his group, the Raised on Cleveland, or rock group, sometimes referred to as YSL, and how they are asserted to be a criminal enterprise under Georgia RICO statutes. Now, part of this is basically a question: is a group of buddies who get together to form a record label, YSL, or Young Stoner Life, or sometimes Young Slime Life, a street gang? Are folks who are successful in rap music simply the targets of overzealous prosecutors? That's what the jury's going to have to answer. Lawyers for the rapper and other defendants say that YSL is simply a successful record label and a collection of friends who portray a gangster image in their music and videos because of tough life circumstances, how they grew up, and because that's what sells. Now, the state asserts otherwise, in large part because the state has been tremendously unsuccessful in thwarting street crime in Atlanta. Now, this is an attempt to clean up the streets by wrapping up the leaders of a street gang. It's a shot across the bow, so to speak, of criminal gangs. If you paid attention during the opening statement, you heard how YSL is related to the Bloods gang and from the LA, and the Bloods gang is adverse to the Crips. And, well, here, let's just look at a little bit of the opening from the state.
And what I expect the evidence to show in this case is that YSL, the group made up of the defendants sitting before you today, along with other both indicted and unindicted co-conspirators, YSL operated as a pack. The quote that I read to you earlier is from one of my favorite books as a kid, The Jungle Book. In case anybody recognized it, those were Rudyard Kipling's words and not mine. But they are appropriate for where we are today. For 10 years and counting, the group calling itself Young Slime Life dominated the Cleveland Avenue community of Fulton County. They created a crater in the middle of Fulton County's Cleveland Avenue community that sucked in the youth, the innocence, and even the lives of some of its youngest members.
Now, I don't know about you, but frankly, I found that kind of painful to watch. Her pacing here was slow, and her clasping her hands in front of her makes it look like she's afraid to talk to these people like people. But she is here carrying a pretty heavy load here. She's got the state of Georgia on her back, so we'll let that go for now. But let's take a listen quickly to how the defense attempts to humanize his client and, to a certain extent, explain some of the rhetoric that the jury is going to hear in some of these rap songs.
Happy holiday season to everyone.
Thank you.
Jeffrey Williams was born into an environment, a community, a society that was filled with depression, despair, hopelessness, and helplessness. He was born, raised in the Jonesboro South housing projects. That's here in Southeast Atlanta. It's a very small 3-bedroom apartment. He lived with his 4 brothers in one of the small bedrooms. His 6 sisters lived in the other small bedroom, and his mother lived in her small bedroom. In the wintertime, it was freezing. In the summertime, it was scorching, because there was not that much money to go around to pay for utilities. The refrigerator the cabinets, hardly ever had any healthy food, and sometimes no food at all. In order to have the appearance of being able to wear different clothing, Jeffrey would share clothing with his brothers and sisters, neighbors, and friends in the community. And although the clothing was oftentimes dirty, at least it gave the appearance that he can have a different look from the day before. When Jeffrey would exit into the community, most homes' windows were boarded up. There were burglar bars on every entrance. Litter. It's not uncommon to find shell casings and human blood remains from the shootings that occurred.
Imagine growing up like that, seeing what other people had and wanting it for yourself. Having to wear somebody else's clothes so it wouldn't look like you didn't have clean clothes. Then imagine becoming more successful than you ever thought possible by channeling that upbringing into rap music. So those are the two contrasts, and the jury is going to have to resolve them. I want you to think about something for a moment. Young stoner life, or young slime life. What does that say about the self-image of these young men? To be considered slime by the rest of society, is that what they're saying? Or are they saying that they're stoners because they have no other place in society? Now, you may think that those are both awful things, and it is certainly nothing to be aspired to. But this is an Atlanta jury, and even though many of the people on that jury may not have grown up exactly the same way in the housing projects and doing things like trading clothes with neighbors, even though they may not have done that themselves, they know people who have. They know people that have pulled themselves up by their bootstraps and made something of themselves, and they know the hurdles that they have faced along the way. Don't underestimate the power of the defense counsel's rhetoric here in this opening statement, particularly where he makes reference to thug being an acronym. It's not a designator. He's not aspiring to be somebody who hurts people. He is totally humble under God. And the reason that he covers his mouth sometimes is because he has rotten teeth because he ate too much candy as a kid. Now, it seems odd that he wouldn't have gone and had those fixed, but there are habits that we develop, even after we get things fixed, that are so ingrained in us that we just naturally do them. So maybe he has now got a full mouthful of teeth that look very nice. He still has to deal with the subconscious knowledge that for a long time, people sort of discarded him because his teeth looked bad. In terms of building some empathy for the defendant and connecting with this jury with that kind of story, as far as I'm concerned, this was a brilliant defense move. Now, it may very well be that these folks are guilty of everything that is being thrown at them. And if they have hurt people, I think that it's really important to punish the people who hurt people. But consider the fact that this guy is sort of the face person. Jeffrey Williams is the face person of this group. And it's doubtful that he sat down at the kitchen table with a notepad and said, okay, here's the ATMs I want you to knock over. Here's the people I want you to assault and hurt. This is not somebody who, at least from his outward appearance, would look like somebody who directs that kind of violence. And so at the beginning, this defense lawyer is sowing the seeds of reasonable doubt. Yeah, he may be involved with a lot of other people, and a lot of other people may like his music because it describes what they do. But that does not make him guilty of the predicate crimes. So this will be an interesting part of the trial to watch. Now, the state has charged Jeffrey Williams, also known as Young Thug, that's his rapper name, with racketeering under the State RICO Act. The original RICO statute was a federal statute, and it's worth noting that the feds are nowhere in this case. Federal RICO law has been very successful against organized crime when it's been charged and when it's made it past the motion to dismiss stage. But it often doesn't make it that far because it has so many moving parts, it's kind of hard to get everything to line up. But rather than look at the federal statute, we're only going to consider the Georgia state statute because Young Thug is charged only under that statute. Now, the Georgia statute defines racketeering much more broadly than federal law does, and Georgia does not always require the existence of an enterprise to constitute racketeering. That is greatly different than federal law. An analysis of the Georgia statute can tell us a little bit more about some of the warts on the Georgia statute. Now, Georgia Code 16-14-4 outlines 4 ways a person can be guilty of violating the racketeering statute. Here's what that says. It shall be unlawful for any person through a pattern of racketeering activity or proceeds derived therefrom to acquire or maintain directly or indirectly any interest in or control of any enterprise, real property, personal property of any nature, including money. Now, obviously, if you have a partnership and a record label and a rap music group, you have an enterprise, and if you spend any of your money on real property, houses or land or personal property, cars, jewelry, guns, or derive money from the pattern of racketeering activity, which are the predicate crimes, you can be charged. B, it shall be unlawful for any person employed by or associated with any enterprise to conduct or participate in, directly or indirectly, such enterprise through a pattern of racketeering activity. You're the guy who designs the cover art for YSL materials, or the guy who drives the van to the concerts, or sets up the equipment, or does the mic checks. Even though you may not know it's a criminal enterprise, according to the state, you are now committing a felony. Ouch. Now, of course, that assumes they can prove mens rea and intent. But now the law specifies further, it shall be unlawful for any person to conspire or endeavor to violate any of the provisions of subsection A or B of this code section. A person violates this subsection when 1. He or she, together with one or more persons, conspires to violate any of the provisions of subsection A or B of this code section, and any one or more of such persons commits any overt act to affect the object of the conspiracy. So if the record label is the cover for the group, driving the van facilitates the conspiracy. And now you're not a chauffeur, you're a co-conspirator. Now here's section 2. He or she endeavors to violate any of the provisions of subsection A or B of this code section and commits any overt act to affect the object of the endeavor. What's the object of the endeavor? Making money through rap music based on fictionalized or perhaps not fictionalized crimes. Again, this code section seems to convert a person with no knowledge and no mens rea into a criminal. Now, I think the courts would still require a showing of some kind of guilty mind or knowledge, but that's not what the statute says. Georgia law isn't finished just yet, though. Just because you engage in a criminal conspiracy and attempt to gain money or property, even if you don't succeed, you can be prosecuted. And remember that reference in the statute to an enterprise? No, not that one. But because under OGCA 16-14-3, enterprise includes any person, sole proprietorship, partnership, corporation, business trust, union chartered under the laws of Georgia. It can also include an ad hoc associations of people. A club could be an enterprise. 4 people working in a partnership could be an enterprise, even if it isn't registered with the state, but especially if it isn't registered with the state. Worse, Georgia has a way of interpreting its statutes so as to avoid the plain language of the statute. Georgia does not require that there is an actual enterprise. They only require the accused acquired any real or personal property, including money, through a pattern of racketeering activity. And here's what pattern of racketeering activity means. engaging in at least 2 acts of racketeering activity in furtherance of one or more incidents, schemes, transactions that have the same or similar intents, results, accomplices, victims, or methods of commission, or otherwise are interrelated by distinguishing characteristics and are not isolated incidents, and it goes on to talk about that. Here are some jury instructions issued in a prior case, and they give us a little bit of an insight into how a jury is instructed on this statute. As you can see, this is from a case tried in 2010, and it says similar or connected offenses or transactions. And it says essentially sometimes evidence is admitted for a limited purpose. Such evidence may be considered by the jury for the sole issue of that purpose. The law provides that evidence of other acts or occurrences of this defendant that are sufficiently similar or connected and therefore purportedly related to the offenses for which the defendant is on trial may be considered for the limited purpose of showing, if it does, the bent of mind and course of conduct of the defendant. So then we come down here a little bit further. And to prove a racketeering influenced corrupt organization's charge under the statute, the state must prove the defendant acquired money or property through a pattern of racketeering activity. Oh, gee, simple, right? And then it says racketeering activity means to commit any of the following crimes: theft by taking, violation of the Georgia Securities Act. So this case was about a Georgia securities fraud. So what the jury instruction is doing there is it's limiting the reach of the act to just those 2 particular crimes. But the actual statute goes a lot further than that. These are just some of the crimes that you can be engaged in RICO for. Unlawful distillation, manufacture, and transportation of alcoholic beverages. Okay, that's pretty clear. That's moonshining. The Georgia Securities Act, homicide in violation of Article 1, assault and battery, kidnapping, false imprisonment, and related offenses, prostitution, burglary, smash and grab burglary, arson, bombs, theft in violation of Article 1, Chapter 8 of this title, robbery, bribery, false statements, impersonating a public officer, attempted murder or threatening of witnesses, perjury, embracery, which I found out is basically going into the jury room and agreeing to take money to do something on behalf of a defendant, influencing witnessing, tampering, intimidation of the grand jury or trial court juror, dangerous drug act, insurance fraud. It's basically a laundry list of pretty much everything you can do that's wrong in Georgia. So simply put, racketeering activity means to commit or attempt to commit any of those crimes. In Georgia, courts have found people guilty of RICO in employee embezzlement cases, Ponzi schemes, credit schemes, complex investment schemes, or a series of thefts that aggregate to over $100,000. The statute's often used to prosecute commercial gambling cases, pain management clinics, and public officials. To be convicted of violating the RICO Act, the state must demonstrate that the defendant is guilty beyond a reasonable doubt. That involves showing a pattern of unlawful conduct and that the offenses committed were the ones included under the RICO Act. A couple of isolated incidents is not going to establish a pattern. Also, the conduct must be criminal. The person committing the racketeering activity must have the requisite intent to be found guilty of the crime. Now, I probably worded that badly there. They don't have the intent to be convicted. What they have to have is the intent, and then if they have that intent, then they're going to be convicted. Not only does somebody face between 5 and 20 years in the slammer for RICO, they can suffer civil judgments as well. In addition to prison time or a fine, the defendant could be subject to civil punishments like, for example, a judge could order him to forfeit his business, allow the state to seize his real and personal property, any of that was obtained through violating the RICO statute, and in addition, a judge can impose an injunction, basically forbidding or directing him to do something. And it goes without saying that all of those predicate crimes that we discussed a moment ago, those can be charged separately in the same indictment. So you can not only be hit with RICO, you can be hit with all those predicate crimes. There are defenses. The most common is to show that there's not a specific pattern that they can establish within the requisite time frame, but most of the defenses relate to things like, having the wrong identification or something like that. They're really, if they can establish that you committed these crimes, the statute is so broad sweeping, it will sweep you in. And again, one of the things that you can show is hey, I didn't have an intention to be involved in criminal conduct. For example, our van driver hypothetical a little bit earlier. But again, that depends on a jury accepting the testimony, and that testimony only comes in subject to cross-examination. As I mentioned, the lack of an enterprise is not dispositive. Georgia doesn't require that there be an actual enterprise like the feds do. They only require that the accused person, acquired any real or personal property. So that's a real problem. Now, the best thing as far as Mr. Williams is concerned is that the state prosecutor is not, I think, on her A game here. Her opening, as I mentioned, was halting, poorly constructed. It drew multiple objections at some points. Instead of providing material as she should have, she was hammered by the defense and the judge for not producing things that were used in her opening before she made her opening statement. That's called trial by ambush, and judges hate that. And her questioning of some of the witnesses has simply been awful. For example, look at this cut where we look at her go through, in a rather painful fashion, some questions about gang activity.
You've talked about the types of activity that you've seen or that Raised on Cleveland engaged in. Did this activity remain confined to strictly the Cleveland Avenue area of Atlanta?
No, ma'am.
Would you tell the jury a little bit about how it touched other parts of the county?
So there were certainly other crimes that route crew members were suspected of. One of them, actually two of the more notable ones that we investigated early on in our working of this gang, one was ATM theft.
Objection. What's the basis, Mr. Sharp? Okay, I got it. I got it. I'm gonna overrule your objection, sir.
People not on trial. I would object to that.
Now, these are incidents that these are personal experiences as well as experiences that Detective Belknap is
Speaking.
I'm gonna overrule the objection.
You may continue.
One of those crimes was ATM thefts. Members were suspected and in some cases arrested and prosecuted for stealing ATM machines all around the metro Atlanta area. Some members were also engaged in armored car robberies. They were robbing the operators of armored cars in several places around the metro area. Their narcotics trafficking and sales were predominantly in the Cleveland Avenue corridor, in that turf or that territory. But some of their aggravated assaults, some of their shootings, and even some of their homicides were in other parts of the city.
Whoever prepped this guy knew what they were doing. You see, he faces the lawyer when the question is asked, but then he swivels around in his chair to address the jury with the answer. And he's ready. He has all of this down. He's probably rehearsed his answers to these questions a dozen times by now. He's a very good witness, but the pacing of the questioning is frustrating, and I imagine it's doubly so for the jury. Now, as I've mentioned before, a lot of the stuff that goes into examining a witness is establishing foundation and things like that, so you have to ask some questions which are fairly routine and they sound somewhat dumb to a jury, but they're necessary in order to get the evidence in. And so some of that can be forgiven, but a lot of her questions were just, tell me what else, I think she probably is very, very nervous about doing this trial. So it's going to be a long trial, and it's going to be a hard one for the state to win, I think. I think this gentleman probably has a pretty good following in the Atlanta area. He probably has people who are inclined to think that the police don't always tell the truth. And I noticed the other day, several other commenters have said that the police officers have been forced to admit that they left things out of their report. And that is not a good look for the cops. So that's what I have for you today. Hopefully you found this interesting, useful. If you have any comments, please leave them in the comments down below, or you can always email me. And if you have the opportunity today, try to do something kind. It will make you feel better, it will make the person you help feel better, and it will make the world a better place. Have a great day, and catch me down here at the beach again tomorrow. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.